Good evening and welcome to Law Talk, the show that brings the controversies and the legal issues of the day into your living room every month. Tonight, I have Daniel Kaki as a special guest and also Mahmoud Fadli with us tonight, and we're going to discuss a couple different topics. So what are we going to look at tonight, Dan?
I believe first up is the Gibson case, the Gibson guitar case. What?
Well, yeah, Gibson Guitar, the company, got in some trouble with the federal government. And what happened here is Gibson Guitar got some wood from India. What do you know about this, Mahmoud?
Well, Gibson Guitar got rosewood from India. It was imported to the United States. This was sometime before 2011. And upon import, the federal, I believe an agency of the federal government raided them, saying that the chain of custody, according to the Lacey Act, was not established for the rosewood, implying that it could have been illegal.
Well, Mahmoud, what is the Lacey Act?
The Lacey Act was passed in 1900, and it was passed by President McKinley. And the Lacey Act essentially was meant to protect endangered species, things that are products of endangered species being imported from other countries into the United States. In 2008, it was amended to include protecting endangered wood products. So certain types of foliage were actually considered endangered, and so now they're protected under the Lacey Act.
So, Dan, what does President McKinley have against Gibson guitars? I mean, what's he got on Gibson anyway?
President McKinley.
Well, that's when they you know, the Lacey Act. What do the feds have on Gibson?
Well, as I read the story, it was the Wall Street Journal story, which I just saw an hour ago, but it sounded like they actually had a document from India, which is where the wood came from, saying that it was not endangered and that it was okay. So
what we had here is the federal government kind of ran with the ball and said, maybe India, in protecting their endangered species, is not working hard enough, or not working as hard as an American company would be if they were trying to protect an endangered species.
Well, it actually goes deeper than that. Under the Lacey Act, the Justice Department has the discretion to interpret foreign laws. So essentially what the Justice Department was saying was that the Indian interpretation of its own laws was incorrect. And so U.S. companies are expected to comply with Justice Department interpretations of foreign law when importing foreign wood products.
So how does the Justice Department define or determine the intent of an Indian law?
They use the same rules of interpretation that they do here in the United States.
They use Scalia's interpretation of.
Oh, sometimes, I'm sure.
Okay, but let's move along. Okay, so this is rosewood from India, right?
Yes.
Now, if Gibson had the fingerboards or the fretboards finished in India, they wouldn't have gotten in trouble. Is that correct?
Right. So the Justice Department is saying that the Indian law requires that only finished rosewood would leave the country and be okay to import, or export rather, to other countries. However, the Indian government actually wrote a little letter to Gibson Guitars waiving this provision in their laws, saying that the unfinished wood being exported was actually compliant with Indian law.
So when this law, this Lacey Act was originally passed, McKinley, was this kind of a protectionist era where they were trying to like keep things being imported in the United States? Is this kind of a residue or a legacy of that time and that kind of intent?
Well, it definitely shows a protectionist effect to some degree. I think at that time there were a lot of environmental concerns. This issue was at the forefront of legal interpretation and efforts by Congress to try and protect endangered species. But definitely there is an aspect of protectionism here.
Okay, so if you're a logging company in the United States, of course you don't want wood being imported from overseas, so you would like to have the Lacey Act strictly enforced.
Yes.
And in this case, if you have a raw product, it's forbidden, but if it's a finished product, then it's okay. So that kind of smacks of protectionism to some degree, it would seem like.
Well,
because you're harvesting the wood nevertheless. I mean,
yes.
you're not necessarily protecting the species one way or another.
Right.
I mean, that seems like a little bit of a...
100 years ago, they weren't really concerned about the survival of the rosewood trees, right?
I don't know.
But and you would think that now, actually, better to finish it here using American labor, right?
Well, yeah, but that would be but then if you're an American logging company and you're cutting down rosewood trees, I'm not sure we have rosewood trees, but whatever the comparable tree would be, you would want to use an American raw product.
Well, the real concern was illegal logging. So the issue under the Lacey Act was whether or not the wood coming from other countries can be traced back to a legitimate source. And so the argument for the Justice Department is saying that the documentation just wasn't there to establish that the logs or the wood coming from India was legitimate.
So they're saying a letter or an endorsement by the Indian government is not sufficient to prove a chain of custody back to where the log was actually cut down in the forest.
Exactly.
Okay, and so if it had been in the United States, you'd be able to see it'd be tagged, or there'd be some paperwork or manifest or whatever to follow this whole process. And here the Indians just wrote a letter saying, you know, everything's fine, and the justice doesn't accept that. Okay, well, now doesn't this kind of hark back? Wasn't there something that happened in Honduras about some lobsters or something like that some time ago?
Yeah, I forgot how many years ago, but there was an issue where 2 people were transporting lobsters out of Honduras. And under the laws of Honduras, the lobsters had to be transported in a box. Unfortunately, they were transported in a bag. And so the Justice Department found this to be a violation of Honduras law under the Lacey Act, which allows them to interpret that law in the first place. And so they got 8 years.
Wow. So they got 8 years as a federal penalty for they were bagging them rather than boxing them, or some kind of.
That's what it looks like.
Some type of container thing. Now this is kind of interesting because, you know, the Lacey Act. You know, isn't there some kind of issues on, you know, sovereign immunity, or on issues of, you know, if it's not of American law? I mean, a person doesn't really have, American really didn't have representation in making that law.
No.
So it seems like there might be some issues as far as standing or constitutionality of interpreting a foreign law. I mean, what if you had a completely, you know, terrible foreign law, right? For instance, that, you know, short people can't, you know, go on the bus or something like that,
right.
You know, and you know you went on the bus there, so that could be the Lacey Act would support something that was a real terrible law.
Only if you're importing the short people. It's
If you're importing the buses, right?
Yeah, consuming them.
consuming them.
Consuming them, okay. But if there could be a situation where you had like a really ridiculous law that the federal government might say, well, we have to support this or something like that.
Well, it's not necessarily that they have to support it. The real concern here is differing interpretations. In the situation with Honduras, the law was not enforced. It was something that the government there just didn't think was important. And under the Lacey Act, the U.S. government said, no, the law says A, B, and C, and therefore you have to comply.
Okay.
How long ago was that?
I do not recall. It was definitely before 2009.
Oh.
Okay, so what's Gibson going to do now? From now on, now they either have to get their fingerboards, you know, manufactured in India, or they have to buy an American wood product, or is there some way that they can, you know, what is the effect on Gibson? You know, I guess they employ, you know, hundreds of people, or maybe 1,000 people.
Sounds
or
like
something.
lots of work for the lawyers.
Does this mean that they're going to be curtailing their production, or how's that going to affect them as a business?
Well, that's one of the problems is we don't know. It's very unclear what the effect is going to be. Are the jobs going to go overseas, or are they going to stay here? One argument is that by allowing this to occur, you're actually forcing companies to have manufacturing done outside of the United States, which jeopardizes jobs in the country.
Because you would think a guitar, you know, in a great part, it's made of wood.
Yeah.
So if you have to do all the finishing overseas, that have a real impact on, you know, already we have an 8.2% or something, you know, unemployment here. So if we're going to ship a few more jobs overseas, that could be a little bit of a problem. Now, what is the political fallout from something like this, from the federal government doing these kind of things?
Well, it could be in the form of just giving the impression that perhaps creating jobs in this country is not important, but I personally feel that that is sort of a stretch. I think the real issue is just uncertainty with regards to imports. I mean, you have cabinet makers, you have furniture makers, you have other industries which utilize wood imports from other countries. And so that would be a big question mark as to, well, what can we do and what can we not do?
Yeah, well, I think there's kind of a trade-off. I think American logging is maybe, you know, $1 billion a year, you know, that's made in American logging, so there's kind of a trade-off.
Right.
You've got things that are going on overseas and, you know, manufacturing and whether you want to do that overseas. But I think also a big issue is that, you know, you've got 400 or 4,000 federal criminal laws that are rather hard to define a lot of times. And this is one of those things that make it difficult for individuals in business really to be sure what their legal standing is before they make some kind of make some kind of legal decision. So Dan, what do you think we're going to, what about, what is it, contextualism versus textualism? What do you
Oh,
think?
you're changing the subject now.
Yeah.
Well, wait. Okay, just let me comment on this Gibson case. I just think.
No, you can't. We got to move
All
on.
right.
Okay, so
Well.
okay. So textualism versus contextualism. What do we got here?
Well, I like this article. So textualism is also called originalism. That's Scalia's position, that you should interpret very strictly based on what the words are of the Constitution, a fine Constitution. And then there's the other position that there's many ways to describe it, but what was the phrase you used?
Like a living constitution.
Living Constitution, yeah. Well, I really liked what it said here. It was Breyer's statement, and so I don't even know where this article came from, but Breyer as being kind of the spokesman of the other pole.
The living constitution kind of theory.
Yeah, so the 3 points were look at the purpose of the law, look at the impact of a decision, and look at try to foster a democratic self-government. The so-called bubble up from below phrase. So I thought that was great. I had never read this before.
So what happens, I guess, Justice Scalia has written a book, and he was kind of taking the whole Supreme Court to task and saying that maybe things have gotten a little bit out of whack here, that the interpretation of the Constitution and law itself has been a little too malleable. It's been a little too flexible to his taste, and he explains why. So what are your feelings on some of the things that Scalia had come up with, Justice Scalia had come up with lately?
Well, he definitely has a different idea of what a constitution actually is. You know, Justice Scalia takes the position that a constitution is not supposed to change. It's not supposed to evolve. That's why we have a constitution in the first place, which is to entrench the values of a society in a document that we can always count on to be the same. And so from his perspective, you're supposed to interpret it as it was written for the actual meanings of the words at the time. That is his position.
Sounds like fundamentalism to me.
Well, yeah. Well, I would say it's originalism, but I think what Thomas Jefferson kind of enunciated was that, and of course there was a lot of people who wrote the Constitution and the Declaration of Independence, and his theory was like the Declaration of Independence was kind of the guiding star as you would the celestial navigation, and the Constitution was your chart. Actually, your in land terms a map, but in sea terms a chart. And they're saying, well, if you deviate from your chart, you can run aground, you can hit the rocks.
Exactly.
They use a lot of sailing analogies because that's how they got around. And then he also said that the jury system or the jury trial, the jury was the anchor that kept the ship of state from going into tyranny. But I think that they were very certain elements of people writing the Jeffersonian outlook was that no, you want to adhere to this very strictly because it keeps you from going into bad areas,
Exactly.
and if you're even a little off, it can cause you some severe problems. So I think that's Scalia's or Justice Scalia's maybe follows that understanding. Or you have, other thinkers of the time, other founders who were like, well, no, this is a negotiated document. We're coming up with a consensus or what we can all sign here. And anything that can be negotiated can be renegotiated.
Right. I mean, there's another perspective that sees a constitution as analogous to a long-term contract, a contract that's going to be executed over a period of years. And the main concern in that type of situation is the change in circumstances. And that's where we get into contextualism, which is what is the meaning of this document? What is the purpose of this document? What is this document trying to entrench? And continuing with the long-term contract analogy is a constitution, by its very nature, cannot anticipate every circumstance that's going to arise. And therefore, to some degree, the interpretation of a constitution needs to be malleable enough so that it can deal with changes in circumstances. And the biggest example is advances in technology.
Yeah, but a lot of people would argue that the human condition for thousands of years has remained essentially the same. I mean, the same moral and ethical issues that people deal with each other haven't changed that much in the last 50, 100, or 1,000 years. People dealing with people always have the same issue. Now, what the Constitution was put together for is because before you always had kings who were anointed by God, and then you had servants who did what the king said, and this was like, no, the people are the king, right? The people are sovereign, right? And the government is our civil servants. They're it's not, it's a government of the people, not, from the government.
Right.
And so basically what you have here is, and I mean, that's why you have your first 10 amendments is like, these are the protections that the people have against their government. So the Constitution, I think, was the first. I mean, there was the, different British law that came before it.
Of course.
That kind of gave us a blueprint for this. But this is the first time they really went and said, like, we want to be protected from our own government, and here's the guarantees. And so I think people are very, I mean, you have the amendment process to change something, but people are very leery of having the government or having any of the three branches of the government change the Constitution because they're leery of the government getting too much control. Because that's the whole thing, is the people are supposed to be in control, which is a very tricky.
Oh yeah, that's dangerous.
Tricky No, but it's hard to do. It's hard to implement.
So I'm just wondering, Mark, why is this even in the news? Why is this?
Because Scalia just wrote this book, and he came out.
I see. And what's the book? What's the book
just came
called?
out, and
What's it called?
I can't remember the title, but he said here's 35 different examples of ways that the Constitution and different legislatures should be analyzed when you're looking at doing jurisprudence on law and Constitution. You should look at what the founders meant when they wrote it at that time, right? So it should be in the context of the time that they wrote it and not yanked out of context and put into a modern era and say, well, if he was in a spaceship, he would have done this. I mean, when people are talking about trade and human relations and that kind of thing, pretty much stays the same as it ever was. And so, where it might have been a barge then, it might be a plane now, but the rules pretty much, as far as the Commerce Clause, should still apply. I think, in a Jeffersonian viewpoint, you probably wouldn't let the Commerce Clause go as far as it did. Right? You would definitely say, well, wait a minute, the Commerce Clause should just handle things that are going interstate, so there's not, so that, citizens go from state to state and have the same rights. It shouldn't be going in and, now we've got the Commerce Clause going as far as, people can't smoke pot here because, it moved from state to state.
Right.
If you use an intercom, even if the intercom's not connected to the telephone system, that's still interstate because it could have been. So, I mean, you have a lot of, broad interpretations that Jefferson wouldn't go along with, but, maybe Adams or some other folks would.
Well, you do have, some progressive interpretations of the Constitution under Scalia's textualist approach, and the biggest example was when Scalia actually was part of the majority opinion in a Fourth Amendment interpretation case where they said that using technological devices which can see through a home or through any place where you have a reasonable expectation of privacy, even if it is taken outside of the home on a public street, is illegal, is an invasion of privacy.
Right.
So that would be one argument to give to Scalia and say, well, in that situation, a textualist approach to interpreting the Constitution can actually lead to progress.
Well, yeah, that could be argued as well, because even you could still say there's another thing is, for instance, the government could have a ladder in the old days to go over a fence. But then let's see what we're going to move on to. We have a little bit of a Romney has been accused of a criminal offense. So, Mahmoud, what happened here?
Well, as best as I could follow in the circumstances, it seems as if Romney was stating in his SEC filings after 1999 up until, I believe, 2002 or 2003, that he was the CEO, president, or manager of his company, which is Bancorp. And his representation to the American people through his campaign was that after 1999, he had nothing to do with Bancorp, which coincides with the period of time where Bancorp actually started to outsource a lot of its jobs. And representatives from the Obama campaign were saying that, well, either you lied to the SEC, which is a felony, or you potentially lied to the American people.
So here we go. Well, first of all, Mitt Romney is running for president of the United States.
Right.
And I guess it was Stephanie Cutter, who's a campaign operative for President Obama and his campaign, says that, well, wait a minute, this guy committed a felony because he put in an SEC filing that he was the CEO.
The SEC filing was on behalf of Bain Capital, right?
Right, but he did say that he was the controlling shareholder, or maybe he was 100% shareholder
I believe he was a sole shareholder.
Yeah, he's a 100% shareholder. He's the CEO.
Wow.
And so, you know, he said that in SEC filing, and then in some election filings, apparently, or at least in some statements, he said, well, I wasn't running the company at that time. You know, because during that time, I guess there were some issues where some companies had been...
He's got some explaining to do.
Some were taken offshore. So what do you think about that, Dan? Is that...
I hadn't really even followed the story, but it sounds pretty embarrassing.
Well, okay, so according to Harvey Pitt, who was a former SEC chairman, he says, well, Bain Capital was required to list Romney because he still owned the controlling shares. But I guess from 1999 to 2002, he was running the Olympics, and he took a leave of absence.
Right.
But
And
then how
then-
could he still be the CEO?
Well, he has an ownership. He owns it, but he's not doing the day-to-day operations. He's not running it.
Well, the Romney campaign is arguing that he was actually in a period of transition from 1999 to 2002, giving control to the other partners. And so during the period of that transition, he was required to place himself as the CEO when, in fact, he had no control. That's their argument.
Right, and then he says they had a leave of absence, and then he retired in 2001, and then they did switch over in ownership and one thing or another. But according to his election disclosure report, he left Bain in February of 1999.
Well, it was a retroactive thing. So I believe it was in 2001 or 2002, he actually retired, but the retirement was signed during those years, but was retroactive to 1999.
Well, I guess the way they put it was that, you know, he decided he wasn't going to return.
Yeah.
I guess it's kind of like a divorce, you know, the day you decide you're leaving without return.
Date of separation.
Yeah, well, date of separation with no intent to return.
Exactly.
So it took him a couple of years to decide he wasn't going to return. So
Counseling, probably.
So there he goes there. So anyway, so we'll see what happens on that. It seems like, you know, it's fairly common for, you know, for CEOs to take leave of absence and that kind of thing. So I don't know how much steam this is going to, you know, how far this is going to go. So you were thinking there was another. You were thinking in the green room there was another felony that Romney could get accused of.
You know, it was very interesting to read this. They were saying that there was, I've forgotten which state, but there was a Romney campaign representative that was giving free sandwiches out to potential voters, saying, "Here's your sandwich, go out and vote." And representatives from the Obama campaign cited an election law which made it a federal felony to give anything of value over $1 to potential voters as part of your campaign. They were saying essentially that he was bribing people with food to vote.
But if you give like a government guaranteed loan to Solyndra for a couple $100 million, that's okay. But okay, so
Well, usually it's the Republican strategy is to keep people from voting, not induce them to vote, right?
So anyway,
I'm not going to comment on that.
okay, so you have Bain Capital, which is kind of a target of the Obama administration, and I guess Bain, you know, what they're arguing is Bain Capital created, you know, what Romney would argue, they created, you know, more jobs than they lost, you know, tens of thousands of jobs. But of course, they were buying up distressed companies, so some of them did fail. And then you have, you know, Solyndra and some of the state-supported companies that Obama gave government guaranteed loans to, and actually to some of the bundlers that had helped with his campaign contributions. I think more than a sandwich worth. And so those didn't do as well. So I think, you know, right now there's kind of a philosophical contest between whether, you know, the bureaucrats or a state-sponsored government, you know, state-sponsored system is more effective than a capitalist or free enterprise system. I mean, what do you think is going to happen there, Dan?
I don't know. I'm thinking about Romney's taxes right now.
Yeah.
but that's very embarrassing also.
Well, I think he's only required to do a year of taxes or 2 years of taxes, but he'll probably have to give some more taxes. I mean, there's always some issues on that, you know. I mean, but I don't think he's required to. I guess the Romney campaign would come back and say, well, we want to see Obama's college transcripts, which he's never revealed, and you know, some issues like why does his Social Security number have such a funny number and all that kind of stuff. So I guess they could do some trade-offs. They can trade the taxes for the college transcripts or something like that. Well, who knows? I would imagine in the end Romney will probably have to give some more years in taxes over just to calm the whole thing down.
You would think so.
You know, but I don't think it's required. You know.
But if it's really true that he hasn't paid taxes in years, that's very embarrassing also.
Yeah, I don't know. We
And
haven't
how
know.
does Harry Reid know? How could Harry Reid possibly know?
Well,
That's a good question.
Harry said that he had somebody at Bain that squealed on, you know,
A disgruntled
that
investor? I don't think so.
squealed on Romney. So I mean, who knows? I don't think it's really a, you know, I don't think
Anyway.
it's going to gather that much steam. But you know, I'm
Well,
just
the
saying.
other thing that interested me was this charge against Romney. This was not by an independent investigator. It was by a Obama campaign person.
Which charge? You mean the felony charge?
Yes.
Oh yeah, it's definitely was the Obama campaign was bringing that forward.
So it's kind of just in the media, right? It's not an actual court case.
No, it's not an indictment, but it is a charge of a felony, which is a pretty serious charge.
It is pretty serious,
I mean,
but,
when you're charging someone with a felony,
Well,
that
but the
would
person who
that
makes-
would disqualify them from being president. That's
But-
for sure. I mean, there'd be a big
Right.
problem.
But there actually is no charge. It's just talk. That is to say, there's no independent investigator. There's no Kevin Starr bringing an indictment.
Well, it would be the attorney general would bring the indictment. I imagine if there was some kind of, you know, there's been no indictment or thing, but it is a serious charge.
It is a serious
you know,
charge,
in a campaign, you have a lot of political talk goes back and forth, but a charge of a felony is a different, is very, very serious charge.
It is.
It's not your typical banter like, oh, this guy doesn't handle the economy well and unemployment's up, or this person, you know, offshore thing and is a greedy guy and, you know, laid people off and doesn't care about employees. I mean, that's your usual political back and forth. But to say someone committed a felony, it's a pretty serious charge in a campaign. You know, it definitely does stand out. You know, you don't see that very often. So on balance, what do you think is going to happen on this felony charge with Romney?
You know, it's election year. It's campaign season, so there's a lot of mudslinging going on both sides.
They'll be hammering it for months.
I mean, again, it's
months.
just part of the campaign process. What actual meaning it has, it's really hard to say. I mean, right now it's a battle for hearts and minds, not necessarily for facts.
Well, I think it's going to be interesting because I think that we're going to have some television blitzes here at the end.
Definitely.
And I imagine the campaign is just going to get more and more, you know, dirtier and more low down as we go on. So anyway, I want to thank you both for coming on the show tonight.
Thank you.
Dan, it's good to see you
Always
again.
a pleasure.
Mahmoud,
Nice to be
pleasure to have you on the show.
Likewise.
And from Law Talk tonight, everyone have a good evening, and we'll see you next month.